Okay, we can start now.
Okay,
Welcome, everyone.
so welcome everyone. My name is Mahtab Alam, and I'm a journalist with The Wire. Uh, and this is the second episode or the second session of the discussion which we are having. The earlier discussion was also on UAPA and other laws, but that was specific to the case related to Bhima Koregaon in Maharashtra. But in today's session, we will be discussing about UAPA and other uh, extraordinary laws like NSA, AFSPA, PSA, and Chhattisgarh Public Safety Act. So these laws we will be discussing and how these laws are affecting people's life and what kind of impact it is having on politics and governance and ordinary people of especially Kashmir, Chhattisgarh, and the series of arrests which has happened and been carried out by Delhi police in Delhi in connection to, protests which were happening before lockdown across India against CA, NRC, and NPR. Uh, and we are joined by three eminent and panelists. We have Bela Bhatia, who is a researcher, activist, and lawyer based in Bastar. She's a former teacher also. She taught at Tata Institute of Social Sciences, but currently and she has extensively worked on issues of human rights, Adivasi rights, and issues of peace and conflict. Currently, she's based in Jagdalpur, and she's been reporting from there. She's also litigating in local courts. Uh, um, so she is with us. She'll be talking about situation in Bastar, what she's being seeing and reporting and writing and litigating. Uh, we also have Dr. Manisha Sethi, who teaches at Nalsar. Earlier, she used to teach at Jamia Millia Islamia. She has extensively worked on terror laws and how it is essentially the very nature of terror laws and these extraordinary laws are prejudiced, uh, and how it is being time and again used against marginalized sections, especially say Muslims, how it is used to criminalize certain sections of society, Adivasis, Dalit, Muslims, and whosoever is dissenting. So she'll be talking about especially UAPA, its genesis, its history, and amendment in UAPA, and how over a period of time from an ordinary law to how it has become an extraordinary law, and especially in after the quota was repealed, how UAPA was several sections of quota and TADA were brought in UAPA and brought an extraordinary, and it was made a extraordinary law. So she'll be talking about that, and in addition to that, she'll be also talking about how in Delhi, specifically, UAPA is being used to criminalize anti-CA protesters, especially those belonging to Muslim communities. There have been several arrests uh, in Delhi. So she'll be talking about that. And we have Mirza Saaib. Mirza Saaib is a lawyer, trained lawyer, and currently he's at Oxford. He's a student of MPP, Master in Public Policy course, and he's been writing on issues relating to Kashmir and PSA, Public Safety Act, uh, how it's been used and misused, what is the problem with, and he'll be also talking about what is the situation in Kashmir, uh, and how the courts have been, say, intervening or away, basically, to intervene in this matter, as we saw today itself. I mean, if you look at today's how the Supreme Court refused to intervene in this matter, and the matter of 4G, allowing people of Kashmir to use 4G. I'm told by several people from Kashmir that the internet is not available. Even the basic telephone was not available in certain areas. Still, it is available in Srinagar, but in other parts, remote parts of Kashmir, it is not available. So he'll be talking about that. And as you know, that several journalists have been booked recently in UAPA, and and how, what kind of effect it is going to have on, say, media and press freedom. He'll be talking about that. So so each panelist will have 10 to 15 minutes. They'll be talking about, and then we will have questions from. I'll be asking few questions from the panelists, and after that, the floor will be open for audience, and they can ask questions. So we'll start with Manisha, Dr. Manisha Sethi, to begin with. Manisha, please. I'm muting myself. Hear you.
Hi. Hi, Mahtab. Hi, everybody. Thanks for organizing this webinar today. Let me just kind of jog everyone through a brief history of UAPA, and that'll help us to understand why what is happening today is really a natural culmination of the very architecture, the very legacy and lineage of this law. Often the term that's used by journalists, by academics, by all of us sometimes is that, a particular law is being misused or abused, right? But in fact, if we look closely at the way in which these laws have been enacted, their very, structure and architecture, we'll find that, incarceration of activists, incarceration of people belonging to specific communities is the only use that a law like UAPA can be actually, put to. So if we are trying to understand UAPA today, as Mahtab said, there have been many amendments, especially after POTA was repealed. So basically, if we look at UAPA, there are two sort of components to it. One belongs to the domain of unlawfulness, which gives the government the power to declare an organization or an association as unlawful. And the other is the domain of terrorism. That is, a government can say, that this is a terrorist act, this particular criminal activity belongs to the domain of terrorism, or that this organization is declared terrorist organization, right? So now, both of these stories are interrelated, but let's start with the beginning, which is in 1967, when this act was promulgated by the parliament. Now, it's interesting that what happened in 1967? Basically, in 1967, you came to an end of an emergency. For a period of at least 3 to 4 years prior to that, there had been continuous emergency in India. People tend to forget when speaking about emergencies. One tends to think only of the emergency imposed by Indira Gandhi. But remember that there were two emergencies declared, one as a result of Chinese incursions into India, and the other during the Indo-Pak War. Now, during this period, the parliament sort of ratified and resurrected a colonial era law, which allowed it to declare certain organizations as unlawful, right? So it accrued to itself the power to declare organizations as unlawful. Now, so these Defense of India rules were sort of ratified during that time, during a period of emergency in India, right? Now, when this emergency ended, a bill was brought into the UAP, the Unlawful Activities Prevention Bill was brought into the parliament, and after two unsuccessful attempts, in the third attempt it was passed. But basically, by the passage of this law, what it did was to bring a law which was meant specifically for an emergency, which was an emergency legislation, which was meant to combat an emergency situation, which is a war with a foreign country, was brought in as a permanent, normalized sort of law. So a law, by law, the government could declare certain organizations as unlawful. Now, prior to that, in 1950, the Supreme Court had already declared that the executive, the government, could not simply unilaterally declare, certain organizations as unlawful. There would have to be judicial scrutiny on whether the restrictions were reasonable or not, right? So now when UAPA is promulgated, there are, of course, voices of dissent, voices of criticism, both within the parliament and outside. And in fact, it's Mr. Atal Bihari Vajpayee who says that this law is a donkey dressed up as a horse. And so you have a law, but of course, the law must meet the test of constitutionality set up by the Supreme Court judgment, very famous landmark judgment called V.G. Rao versus State of Madras, which, as I said, clearly lays out that the government cannot unilaterally declare an organization as unlawful. There has to be a judicial scrutiny. A judicial officer has to decide whether it is reasonable or not. So now, in order to do that, it brings in a provision which says that yes, there has to be a tribunal. We'll come to that bit on the tribunal in just a minute. So what does UAPA do? It empowers, as I said, a government to declare certain associations as unlawful if it comes to the opinion that this association or its members are engaged in secessionist activities, or intend to undertake secessionist activities, or are supporting secessionist activities, or are defying hate speech laws, or are questioning or disclaiming India's sovereignty and territorial integrity. So now just look at the use of these terms, intention, questioning, disclaiming, supporting. Now it's a very, very slope, it's a very slippery slope and a very messy field, right? And so basically what this law is doing is it is giving the power to the state, to the executive, which can decide on the basis of its own subjective opinion, on the basis of its own ideological predilections, as to whether a certain organization constitutes an enemy of the state or not. So now it is the first characteristic of UAPF right from the beginning is that it is subjective, it is ideological, depending upon the party in power, right? So that so it is ideological. So of course we know that there are certain organizations which are banned repeatedly, for example, soon the Islamic Movement of India, but the other organizations which many government commissions have indicted for participating in actual violence and communal violence have never been or are treated with kids gloves and not declared unlawful. So there is at the heart of UAPA a very subjective bias of the executive, right? Now, so as I was saying, but because of the V.G. Rao judgment, the state has, the law requires that it meets this test of constitutionality. So therefore, there has to be a judicial scrutiny. So now, a provision in UAPA says that there has to be a tribunal by the sitting court of a High Court judge of the Delhi High Court, who would then examine. There would be material placed before him or her that whether the restrictions, whether there are grounds to actually curtail the freedom of an association which has been declared as banned or unlawful. Now, the problem with this is, let's take the example of Students' Islamic Movement of India. Now, it was banned first in 2001, and it was very much to do with what was happening internationally, the global sort of winds of Islamophobia post 9/11, and the linking of Simi with, Bin Laden and so on and so forth. So in 2001, it's banned. Now there have been successively tribunals every 2 years. Now earlier in UAPA, the ban could last for 2 years. Now since 2014, the ban is for 5 years. So in every single tribunal, except for one in 2008, every tribunal upheld the ban on Simi. Now, there's a lot of talk these days about, executive-minded judiciary and sealed envelope jurisprudence. But if you look at the Simi tribunals, you will see how well entrenched both the executive-mindedness is as well as the sealed. Every time the tribunal happens, there is actually, the deciding factor is what is given to the presiding judge in a sealed envelope, right? And sealed envelope means that it cannot be shared with the organization which is contesting the ban. and SIMI is probably the only organization which has consistently challenged the ban on its, the ban imposed on its existence. So really, you're saying that we are, it's lawful because we are allowing the organization to challenge it, but but the odds are so much stacked against the organization which is banned that it's almost impossible to challenge it. And the other thing is because so there is a kind of a symbiosis between the tribunal, the prohibition, and the FIRs. Now again today, there's been in the Supreme Court Saab's case where it has been noted that all the FIRs are cyclostyled and quite identical to each other. Now, if you were to look at UAPA cases, you will find that almost every FIR looks like every single other FIR. Right? Now, for example, violence. It's not seen any extensive, violence which would classify as terrorism. But if you go to Madhya Pradesh, in district after district, there are dozens of cases booked against young Muslim men, and sometimes not so young, for being members of SIMI. And all of these cases are quite identical. That they were propagating, the ideology of SIMI on the market square or something. And they said, okay, if SIMI has been banned, we don't care. We will continue to run the organization. So very identical stories in all of them, very identical, recoveries. And because I just want to come back to the definition of unlawful activity, actually, in the way which it is defined in the Act. So unlawful activity means it includes, word, speech, written word, speech, gesture, visible representation, sign. So anything basically what you're saying, what you're singing, what you're writing, what you're painting could be construed as belonging to the domain of unlawful. If you don't subscribe to the mainstream narrative of nationalism, then it's very easy to dump you into the dustbin of unlawfulness, right? So now so on the one hand, there is a subjective bias. On the other hand, this very open definition of unlawfulness, which allows a whole range of human activities to be categorized as unlawful. Then you have a situation, if you look, so it really plays, both of these things play out in the way in which FIRs are written. That is, there is no specific allegation. They are vague. They just talk about some vague conspiracy. There's nothing specific. The evidence is usually recovered literature, because how do you prove membership of an organization which has been banned, right? It is only through recovered through magazines, through membership slips, and so on. So if you look at the SIMI cases, for example, you will find that in the early years, right after the ban, the police would produce as evidence copies of Islamic movement, which had been, of course, seized in the raids across offices in SIMI offices in India. Then after a while, when of course probably the supply of Islamic movement kind of waned, then you start finding photocopies of Islamic movement being produced as evidence in SIMI cases. So this is the way in which membership is to be proved. Now, of course, many judgments in the Supreme Court and various high courts have said that membership is only active membership has to be considered, passive membership is not to be considered, and so on. But actually, in the way in which the law works, there is no distinction made between active and passive. So as long, and of course, everything is so subjective. So you could say that you sympathize with a certain movement. So the range of unlawfulness just grows and grows and grows. Now, so since the other important thing is that of course they say that the judicial scrutiny of the tribunal is not. Mahtab, just tell me when to end, because I can just go on. So on the one hand, you have the tribunal where the various state governments are producing all this material. So every time there's a tribunal, the state governments will come and say, oh, but we've booked these 20 FIRs in the last year against, so which shows that SIMI is active, right? So that becomes grounds for further prohibitions, further proscription of an organization. And because there is a ban on an organization, it continues to allow policemen to book young Muslim men under the under UAPA, saying that, oh, they're members of SIMI and so on. So there's a kind of a symbiotic relationship between the ban itself and the registration of FIRs. So now, that's what in a nutshell what unlawful activities part of the UAPA is. The other part, as I said, was the part of terrorism, which comes, as Mahtab pointed out in his introduction, from when POTA was repealed. Now, TADA and POTA, as we know, were the precursors to this fortified UAPA. TADA was promulgated in 1985 in response to the insurgency in Punjab, and and this is the first time when terrorism actually gets defined. But again, just as unlawful activity is so vague and so broad, so and it can incorporate everything. Similarly, terrorism, the Terrorist Act is so vague, both in TADA and POTA, where it was kind of just copied from TADA. So Terrorist Act would include a variety of violent crimes, but which is defined or characterized by intention to strike terror. Now again, intention is a very subjective word, intention. So all other things being equal, so all kinds of crimes like murder, use of explosives, use of weapons, all of which are also covered under ordinary criminal law, are included within the definition of terrorism or Terrorist Act. But what differentiates it from ordinary criminal activity is the intention to strike terror. So now imagine a situation where the policeman sees, let's talk about TADA, for example. In TADA years, a policeman comes across two people. One of them is a Sikh, one is a non-Sikh. So in the case of the Sikh person, the police is kind of free to apply TADA, right? And so it's very much the the subjective discretion. It is the arbitrariness is the very basis of the way in which terrorism is defined. So it's the intention to strike terror, right? And the intention is not kind of defined anywhere very clearly as to what could constitute the intention. So I mean, the vagueness is very striking. In fact, in Punjab, at one point, the government had to tell the police that please stop registering cases under TADA when you have the option of using ordinary criminal law, right? Because it's so arbitrary. It allows you to say, oh, this crime, this murder is a terrorist act, but this murder is just an ordinary murder. So we can, just try them under 302, 307, but this needs the invocation of TADA or POTA or now the UAPA, right? So now both TADA and POTA, I'm just going to rush through it, that both there is a huge, mountain of evidence which shows that both TADA and POTA were used to target minorities, to target political dissidents, to target the most marginalized sections. For example, in Bihar, Bela's worked extensively on that. TADA was used only against landless labor. Whenever there were, there was violence, TADA was used only against landless laborers who had, organized under various ML groups. But it was never invoked against the various militias of the private militias of the landlords. And even when a couple of times it was imposed, it was quickly revoked. So you have it. So the subjective basis of the way in which these laws are used are clearly visible. Right now in POTA again, it was in fact the most use of POTA was in Andhra Pradesh and in Jharkhand, where a large number of tribals from young to the elderly were incarcerated under POTA. Now the point I'm trying to make is that there is a clear evidence of the way in which POTA and TADA and now the UAPA are used to target specific groups. Now these can be political dissidents, but they can also be religious, social religious categories, as we've seen how over the years the use of UAPA, the use of UAPA against SIMI has actually led to the wholesale criminalization of Muslim community. Now, I just want to quickly, and so when POTA was repealed in 2004 in face of such mounting evidence, UAPA was fortified. Many of these sections, as Mehta was saying, many of these sections were brought in. So the chapter on terrorism was added onto UAPA after POTA was repealed because no government wants to, seem weak on terror. So a chapter on terrorism was added, and many of the same provisions which people had agitated against, which people had said, is against Constitution, is against our history of, is against the principles of established principles of jurisprudence, etc., etc. The evidentiary shortcuts that we use, all of those were absorbed into UAPA. And now I just want to briefly talk about what's happening in Delhi. So it is with this legacy of laws, UAPA strengthened through, POTA and TADA, that you have the criminalization of anti-CA protesters. We know that from mid-December, a very inspiring, very significant struggle was launched in and around Jamia, in Shaheen Bagh, in Jamia, and which inspired, similar kinds of protests across the country. Now, and in February, there was, and throughout this period, there has been very incendiary kind of statements made by right-wing leaders about how to deal with anti-CA protesters, that they were anti-nationals, that they should be sent to, wherever they're supposed to be sent off to. Now, in late February, there was outbreak of communal violence in Northeast Delhi, in which disproportionately those who suffered were Muslims. Now, what has happened in now is that even in the cases in Northeast Delhi, a large number of Muslims have been arraigned in specific FIRs. But in addition to these specific FIRs about specific cases of arson, murder, etc., during the period of the violence, there is also an overarching omnibus FIR which has been lodged by the special cell, which is about this conspiracy of executing and planning violence in Northeast Delhi. So now, if you look at that FIR, and it is under this FIR that a large number that these people have been booked. Students from Jamia, alumni from Jamia, Safura, Miran, Heather, Shifa Rahman, all of them have been booked under this specific FIR of conspiring to, execute this violence in Northeast Delhi. Now, so what it does is, so of course, if you look at the way in which UAPA works, so UAPA was not invoked in the first, in the first go. They were just all all bailable sections, but slowly some other non-bailable sections were added, and ultimately UAPA was added. Now, as the history of UAPA and before that POTA and TADA has shown, that UAPA is used because the bail provisions are so tough. Mahtab Alam? Okay, in 1 minute. So the bail provisions are so tough that it is impossible both UAP and before the other laws, they functioned as preventive detention laws. Now the rate of acquittal is very low. In TADA it was less than 1% actually. In UAPA it's higher, but still it's 75% cases end in acquittal. But the point is that because bail is not possible, as in this case, people will continue to be in jail for a long time. And at the end of it, they may be acquitted. We don't know at the end of these, 90 days, 180 days, whether the police will actually be able to file a charge sheet or not. We don't know, but it allows them to be kept in, in prison, incarcerated for this long period. So it works as a preventive detention law. It is criminalizing a protest which was peaceful, which was democratic, which was talking about the constitution. It criminalizes that. But it just not only criminalizes that protest, but if you look at the FIR, it criminalizes the entire Muslim community. It talks about how Muslims were involved in agitating. Muslim women were standing outside Jafrabad metro station. Their kids were there, so they wouldn't allow, and so on. So the Muslims didn't send their kids to school on the day the violence broke out. So it's not just criminalizing these anti-CA protesters, but it's actually criminalizing the whole community, which is itself a legacy of UAPA. Now, thirdly, it allows, it gives a total clean sheet to those who actually made very, incendiary remarks, inciting violence, right? We know who all they are. So we can have a longer discussion in the Q&A, but I just wanted to say that these laws are not really, there's no misuse or abuse. This is what these laws are meant for, from the very start. No, unmute yourself.
Mahtab, you are muted. On your control panel, there'll be a button to unmute yourself.
I can't hear. Mahtab, nobody can hear you.
Yeah.
Now we can.
Yeah, thank you, Manisha, for this. Now we'll go to Bela. Can you hear me, Bela? You have to unmute yourself.
Yeah. Okay.
Yeah. Now I request Bela to talk about situation in Bastar, how UAPA is being used over a period of time in Bastar, in Chhattisgarh, especially our central India, Odisha, Jharkhand, and Chhattisgarh. And also the specific this Chhattisgarh Public Safety Act was enacted and used against several people. Recently, we saw the acquittal of Ajay TG, who was booked under Chhattisgarh Public Safety Act. So, if you can talk about that, and as I was discussing earlier, that it will be if you can also talk about if there is any change between the two regimes we have been seeing now. I mean, before 2019, and or what is the situation after 2019? I'm talking about the state government. Since Chhattisgarh Public Safety Act is a state law, I think it would be in, and a special, and also there were attacks on journalists and activists, constant attacks in those days. So, and the Salva Judum, all those things, if you can cover.
Yeah, sure. Okay, so there's lots to cover. See, besides the UAPA, which of course applies to the country as a whole, we know that there are state-specific laws also. These special laws. I mean, Maharashtra has Makoka, Madhya Pradesh has its own act, and similarly in Chhattisgarh also we have what is called the CSPSA, that is the Chhattisgarh Special Public Security Act. In Hindi, it is called the Chhattisgarh Vishesh Jan Suraksha Adhiniyam. Now, this act was enacted in 2005, and this was passed by the Chhattisgarh State Assembly in December 2005, and it came into effect in April 2006. Now, the timing is very important here because those of us who are following Chhattisgarh and who are following Bastar, we know what was happening in 2005. We know that in June 2005, the government and both governments at that, the center and the state, had together, started launched a very severe counterinsurgency operation, which was the beginning of the whole militarization that has happened in Bastar since. It led to strategic hamleting. It led to all kinds of methods which were used, where civilians were armed, SPOs, the special police officers, were formed, which were later outlawed in 2011, and so on. So this is the time that the CSPSA also takes birth. And certainly, I think we need to ask a question as to why did the government need the CSPSA? It already had the the IPC. It had the UAPA, and by then, by an amendment in 2004, the CPI Maoist, as well as all its related organizations, had already been banned. So why the CSPSA? Once you are a student of the counterinsurgency that has happened here, and continues since 2005 till today, in the shape of so many different types of operations that have happened, from Salva Judum to Operation Green Hunt to many operations. What is very obvious is that CSPSA was another tool in the hands of the state to further the illegitimate aspects and objectives of its counterinsurgency. Because now there have been many cases in courts, at the local level, at the High Court level, and the Supreme Court level, where we have even enough evidence to show that the government was overstepping, the rule of law, in many ways. Now, the CSPSA was heavily criticized by national and international human rights and media organizations, and it was widely held that the definition of unlawful activities in the Act was such that it could be used to throttle the right to free speech, democratic dissent, and endanger the fundamental rights enshrined in Articles 14, in Articles 19, 20, 21, 22, and 300A of the Constitution. In fact, there's a very lengthy and a very powerful litigation that was filed by the PUCL, Chhattisgarh, in the Supreme Court of India, challenging this act, because at the time, already there were, individuals who had widespread credibility in the society, like Dr. Vinayak Sen, like, T.G. Ajay. So whether you are a doctor or whether you are a media person, or there were others who were in Sarguja, so altogether some 12 or 14 persons were highlighted in this petition by the PUCL, and they had filed it in the Supreme Court of India. Unfortunately, it has still not moved that much, but a challenge to the undemocratic and the draconian aspects of CSPSA were very emphatically registered at that stage itself. Now, what is important to note is that we can think of CSPSA's journey in two phases between 2005 to 2015 and 2015 onwards. Why I mark 2015 as a kind of a line is because it was then that the NIA court was opened up here in Bastar, and since then what we notice is that a lot of the cases, CSPSA, the people being charged under CSPSA was getting reduced, and people being charged under UAPA was, has been increasing. And it's all, under the, any case that is, which has a UAPA charge on it or a CSPSA charge on it, it automatically is then under the NIA court, purview of the NIA court in Jagdalpur, and all those prisoners are kept in the Jagdalpur jail. Now, the legality of this, is being challenged in the High Court. Such a petition, a public interest litigation, has been filed by Advocate Shikha Pandey. The petitioner is Senior Advocate Hari Degal of Dantewada. And they have filed this petition. It is still to be heard, but it's a very important move because because there is something like an NIA court, and that these special sort of cases have to come to this court. What it means is that it causes a lot of problems for family members who have to travel long distances from the various different districts that they come from, and it causes a lot of pressure on this one court, because the court is it's not as though it is it has special number of people in it to man it. So for example, if the judge of the NIA court goes on leave, or if the typist goes on leave, or if the babu goes on leave, then again there's a postponement. So and of course the fact that the Jagdalpur jail is therefore very it is heavily overcrowded. Right now it is, I think the exact capacity I do not know, but I think it is more than 3,000 persons are there right now, while its capacity I think is 1,600 or something like that. And even now, when after the Supreme Court, after this whole COVID crisis began, and the Supreme Court order, which said that from jails, people should, get released. Those who have, who are convicted with a 7-year sentence or less. So from Jagdalpur jail, so far only 63 persons have been, released, and while the capacity of the jail is something like at least 40 times more. Now, how does this work on the ground? How does CSPSA, UAPA work on the ground? Because even at the time when Binayak and others were charged under these, and there was a lot of all over the country, there was a lot of attention, not only country, internationally. It was an international issue, human rights abuse issue, and rightly so. But even then, at the time also, there were, from what I've heard, there were already, something like 113 persons who were charged by CSPA, under CSPSA, including a 13-year-old girl. Now, I don't have exact data about it, but this is what I'd heard at that time. So usually what happens is that we do get to know and hear about high-profile cases, but we do not get to know about, a very large majority who is, stamped with the very same acts and the very same consequences, that this of such a terror law. In Bastar, again, very rough kind of estimate that I have is that by end 2019, roughly 200 or so UAPA cases had been disposed of, and around an equal number, something like 96 were pending. And CSPSA figures I do not have. Though there are, many cases where individuals have CSPSA on them as well as UAPA on them. Arbitrary arrests are very common in Bastar. So somebody may be going to the bazaar, somebody may be going to the jungle, somebody may be going to go and get their ration. Any of these places, even going to the hospital for that matter, any of these places, you can get picked up. And then what you get charged under is in some ways your luck, whether you have slightly less charge on you or more charge on you. Because the thing is that there are loads of cases jisme agyat hai, unknown people, So therefore it gives the state ample chance to fill these unknown people, with any persons it catches. So as I said, I mean, it is really chance. I mean, there are some kind of charges which are very, very common. As a lawyer, you sometimes, you think that, different cases would be different, but often what you find is that most of them are charged under, IPC sections 147, 148, 149, which is all writing sections, and 120B, which is criminal conspiracy. Or there'll be explosive substance, with Explosive Substances Act, or Indian Arms Act 2527, along with CSPSA and UAPA, or sometimes one of them. Now in CSPSA, again, if you see, then you will see that they are usually charging them with under Section 8, 135. Now Section 8 of CSPSA 135 is, if I may just read it for you, it says 8.1 is whoever is a member of an unlawful organization or takes part in meetings or activities of any such organization, or contributes or receives or solicits any contribution for the purpose of any such organization shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Section 8.3 is whoever manages or assists in the management of an unlawful organization, or promotes or assists in promoting a meeting of any such organization, or any member thereof, or in any way indulges in any unlawful activity of such organization in any manner or through whatever medium or device, shall be punished with imprisonment for a term which may extend to 3 years, and also liable to fine. And 5 is whoever commits or abets or attempts to commit or plans to commit any unlawful activity in any specified area shall be punished with imprisonment for a term which may extend to 7 years and be liable to fine. Now the thing is that each of this is, uh, uh, it's very flexible. It depends on who is reading it, who is interpreting it. Likewise in UAPA, it's usually section 38 which is used, which deals with offense relating to membership of a terrorist organization, and or uh, uh, 39, which is offense relating to support given to a terrorist organization. And here again, anything can be used. It can be, funding can be used. Apne unko, if you have given them food, or I mean, all this. If you have attended a meeting, another thing is that often in areas of Maoist influence, if the Maoists are calling for a meeting, I mean, people do not have a choice in the matter. I mean, you cannot say, okay, I'm sorry, but I don't want to attend your meeting. You don't do that. I mean, everybody will attend that meeting. Now, how do you figure out who is doing it voluntarily, who is doing it involuntarily? Similarly, they may ask somebody to go and collect food grain. Now, again, that person will go house to house and will collect food grain enough, whatever they need. And again, how do you know this is being done voluntarily or involuntarily? Similarly, often the Maoists do not want the police to get into those areas, and therefore they may dig trenches. They may, or they may dig across a road. Now, for all this, again, they may, get people from that surrounding area. Now, again, so all these people are vulnerable. So basically, anybody, any citizen who is residing in those parts, is vulnerable, because there are Maoists are active. There are, incidents which continue to happen, and therefore, any individual is, vulnerable, because the government is not only picking up those who are in, fatigues, in the Maoist, uniform. So as a result, most of these people who are picked up are, in that kind of category. Here, let me also mention 2 incidents, just to give you an idea. You may have heard about the Burqa Pal incident. This happened in Sukma district. This happened on the 24th of April 2017. And, in this incident, some 25 CRPF were killed and 7 were injured. And what had happened is basically this, that there was a road being built there, and there was force there to, sort of protect the construction, whatever was going on. And that is when, this big ambush or attack happened, and in which the lives of so many were lost. Now, this happened in Burqa Pal. So the assumption, therefore, of the police, of the government will be that Burqa Pal people are, of course, heavily into it, are involved in it, and the people in the surrounding areas. So therefore, in this Burqa Pal incident, they have caught something like 116 people, in this case. And besides that, 120 are farar. तो इसमें क्या है कि कभी भी अभी जैसे ये है उसका फाइनल स्टेटमेंट है. सो ये जो आपको मैं ये शायद दिख नहीं रहा है. So these are all names of people. These are all names of people, and then there is, and this is the name of those who are, farar. 120 of them. So what it means is that again, in a case like this, at any given point of time, they can bring in more people. And the legal process is such that if the process has moved, like let us say it has moved from the remand to the charge stage and from the charge to the evidence stage, if at that stage they find new people, let us say in that case, the whole case will stop. It will wait for the others to catch up, and then it will continue. So that itself is it's a highly मतलब ये बहुत बड़ा अन्याय है, क्योंकि ऑलरेडी उस समय तक लोग जेल में बैठे, अभी जैसे ये बुर्कापाल वालों का ही ये 2017 से है, ठीक है, जेल में। इनका आज दिन तक इनका चार्ज नहीं लगा है अभी तक। चार्ज इज द फर्स्ट स्टेज ऑफ द ट्रायल। अभी तक इनका चार्ज ही नहीं लगा है। एंड अनचार्ज क्यों नहीं लगा है? So because there are so many, 116, so therefore, they need the constables. That is what they argue. The court argues that we need those many constables to bring them. They cannot be brought all together. So initially, as lawyers, you are arguing that bring them in batches. But then initially they were not agreeing. Then they finally agreed to do that in batches. Then in between elections happened. I mean, 2 elections happened. So therefore, all the arakshaks are in the election. So ऐसे करते आज दिन today now it's 2020 and इन लोगों का अभी तक चार्ज भी बुर्कापाल का नहीं लगा है. And today, what is the situation now in Corona times? The court is shut. Okay. Already, bail applications for these people had been made, and bail had been rejected because bail in court Naxali cases are never granted. Never. It's almost like a rule that they are just never granted. But the thing is that you need to get that rejection in order to go to the High Court. And even when you go to the High Court, you find that a similar bias is there also, that except in very rare cases, mostly the bail is not given there. So even in this Burkapal case, already, for many of the accused, bail attempt had already been made, and they had got rejection. During Corona now, we are so keen as lawyers to actually file the bail again, to say that this is Corona times, and एक केस में एक साथ अगर 120 लोग 116 लोग निकलेंगे अगर आप बेल देते हैं तो ये उनके हित में है, मगर जेल बंद है. हाई कोर्ट ने ऐसे कहा है कि ओनली इन अर्जेंट मैटर्स कैन यू अप्रोच द जेल द कोर्ट, and it has not defined what is this urgent matter. While to me as a lawyer, I mean, each of these matters is urgent. There are some cases where only one witness, and that too a very insignificant witness, baki tha, and the case is, to be closed. Now, is that an urgent matter or is it not an urgent matter? I mean, how do we define what is an urgent matter? So right now, to my mind, I think it is, pretty criminal that the courts are closed, while it is very possible in court to maintain social distancing and continue our work. So so इस तरह ये है बुर्कापाल की कहानी. उसी तरह जैसे चोलनार भी एक दूसरा गांव है, वहां पे भी इसी तरह से एक आईडी ब्लास्ट हुआ था जिसमें कुछ 6 या 7 फोर्स वाले मर गए थे. उसमें इन्होंने 16 लोगों को, आसपास के लोगों को उन्होंने अरेस्ट करके रखा है. वहां पे एविडेंस में स्टेज अभी आ गया है, but it is moving very slowly. Why? Because most of the witnesses are usually in these cases, are the police and the paramilitary. They may be DRG or belonging to one or the other force, and often they just don't come. They don't come. So you'll have, and a hearing is once a month. So from this month, from May it will go to June, from June it will go to July. It's not as though आज नहीं है तो अगले हफ्ते मिल जाएगा तारीख. तो इस तरह से क्या होता है कि लोग मतलब जेल में पड़े रहते हैं. एंड यहाँ पे आपने सुना होगा कि नई सरकार में उन्होंने ये बंदी मुक्ति के लिए उन्होंने एक कमेटी बनाया, पटनायक कमेटी बनाया. and the Patna committee is meeting, and but at the same time, there was Andolan around this issue, and we had all gone to meet the chief minister, and the chief minister had that time promised that there would be a subcommittee made, which would operate in Jagdalpur, so that it would be easier for us to give petitions, etc., to the subcommittee. But so far, we had met the chief minister sometime late last year, and so far no subcommittee has been made. So as a result, one is astounded that on the one hand, the Supreme Court says that you should get you should try to decongest the prisons, but on the other hand, there is no ceasefire. While this is the time when actually there should be a ceasefire, already the Andhra and the Odisha border committee of the Maoists had actually announced a unilateral ceasefire and asked the governments to respond, but nor did Andhra government respond, nor did Odisha government respond. And some journalists who asked the IG Bhaskar about this, he said that if their committee here, if they make a move, we will meet, we will give a positive response. But I feel that it is a very important issue, for everybody's welfare, that the government should not wait for somebody or the other. Each side should not wait for the other, but this is a time for a ceasefire, so that one can better care for, because right now there are a lot of people from these villages who are on the borders, who go regularly for the mirchi picking season. You may have heard about this 12-year-old girl who died because she...
Can we stop here and then discuss about this in the question answer, if
Sure.
that is possible? Sorry,
that is fine. I will just end with just one last thing, that just as because I mean this also concerns with UAPA and so on, that one is where the state like the Burkapal and the Chollar incidents are one kind of incidents. Then you have the Nurkatong kind of an incident where it was a clear case of a fake encounter and it had become a big issue. 15 Adivasis got killed, and there the police picked up two persons, Budri and Deva, who were since then who are in prison and who are charged with UAPA. And same thing, their case is not moving because the police, Konta police, is not cooperative, is not coming.
Yeah, thank you, Bela. Can I now request Mirza Saaib to talk about situation in Kashmir and use of PSA specifically, PSA, and it is interesting to note and see that the chief ministers who were infamous for using PSA during their tenure, now they are charged under PSA, and what is happening in Kashmir and PSA as well as AFSPA.
Thank you for having me. Am I audible?
Yeah.
Okay. So thank you for having me. Before the session, I had sent out a video today. I don't know if everyone has a chance to see that, but for anyone who hasn't seen the video that I'd sent out, it's a video of a doctor who was being detained, who was not even protesting in Kashmir. He had just come in the early days of the lockdown, and the lockdown had just started in Kashmir after August 5, to protest, to basically assert and request that his patients were unable to come to get dialysis. Patients who required chemotherapy, they were unable to come and get what they required. But this request was also met with a detention of this person. So the video was just to show all the kinds of things that people can get detained for in Kashmir. Now, over the course of the next 10 minutes that have been allotted to me, I will just be discussing three things. The first is the overarching structure of the laws that are used to suppress Kashmiris: the Public Safety Act, the AFSPA, and now more recently the UAPA, as well as the institutions like the NIA. So the second thing will be the role of the court in aiding the violation of rights by the government. And finally, there's some drawings that have been that certain members of a group called the Kashmir Reading Room have made, which I'll also be circulating. I'll ask Manisha to just circulate them. Now, to begin with, India's anti-terror legislations and detention laws, they are essentially a return of the Raj, as Manisha had earlier pointed out, a colonial era laws. Now, and India post-independence had assumed this ethical gravitas of an anti-colonial nationalism. But the laws that are used by India to counter Kashmiri nationalism exhibit a reversal of India's anti-colonial stance. And this colonial employment of legislation, it involves a systemic and structural dominance with the intention of ensuring subservience. But this is not just today. This is not just in the time of BJP or Narendra Modi. Throughout the political history of Kashmir, since 1947, you will see a recurring theme that India is not satisfied with mere interference in our democratic exercise. India wants to dominate it and in turn ensure our subservience. So by using these laws, India controls the narrative through which Indian rule in Kashmir is perceived and experienced. There is no tolerance for any kind of dissent, despite the tremendous economic exploitation, militarization, egregious human rights violations that have been going on for decades now. So by using laws like the PSA and the UAPA, India exercises more control over the narrative of Kashmir. And this narrative is then employed to portray Kashmiris as approvers of anti-minority violence, or to portray Kashmiris as believers in religious barbarism, or to claim that Kashmiris do it all at the behest of Pakistan. So I'll just quickly go over the overarching structure of laws that is present in Kashmir. So to begin with, there is sedition on dissent, which is there in many places in India. But in Kashmir, there's just a heightened level of treatment towards the Kashmiris. The UAPA is the second part, but I will not go into the law itself because that has been already dealt with extensively. But I will point this out that Amit Shah had used a circular logic to explain this law when the amendment was being made in the parliament. And he said that the only individuals who need to fear this process, the process of being designated as terrorists, are people who are terrorists. And I quote over here, where he said that मैं मानता हूं कि आतंकवाद बंदूक से पैदा नहीं होता, आतंकवाद को फैलाने के लिए जो अप्रचार होता है वो आतंकवाद का मूल है. Now, what classifies as अप्रचार and what classifies as प्रचार, campaign, preaching or propaganda, is left to the definitions, is left to the imagination of the government in power. So there is no definition given of what constitutes as bad campaigning. And Amit Shah tried to reassure everyone by saying that इस कानून से किसी को डरने की जरूरत नहीं है, बस आतंकवादी को डरना चाहिए. But over the last 1 month in Kashmir, we have seen the UAPA being used against journalists in Kashmir, Masarat Zahra, Pirzada Ashik, Gohar Jilani, and this was being done to send a message that no narrative, apart from the narrative of the government, only the government's narrative can be tolerated and no other narrative will be tolerated. But it's also really relevant to mention over here that these journalists who were charged under the UAPA, their actions were not even that radical, or their posts were not even so seditious, if I may use the term. In fact, Masarat Zahra was only uploading photos which she had taken, which had already been published in reputed newspapers from around the world, and she was just uploading them on her own social media. So the message that was being given is that nothing can be tolerated, no dissent will be tolerated. And this is the last nail in the coffin for press freedom in Kashmir, where even under normal circumstances, there is tremendous control over the press. And journalists like Asif Sultan are still in jail for performing their job as journalists. In fact, the Jammu and Kashmir High Court refused to even entertain interim protection from arrest to the journalists who were booked under UAPA. Justice Ali Muhammad Magre, who is the only Muslim judge of the Jammu and Kashmir High Court, through video conferencing, he denied any interim protection from arrest. Now, this is the first part. The second is the Public Safety Act. The Public Safety Act in Jammu and Kashmir is a law which is used to ban the circulation of people and the circulation of ideas. And once you are charged with the Public Safety Act, you have no access to lawyers also. Originally, this law was enacted to prevent timber smuggling in Kashmir, but it was used by the Sheikh Abdullah government in 1977 to detain political dissidents. And as Mahtab pointed out, that it's quite amusing that even chief ministers who have been very zealous in using the Public Safety Act are now in detention under the Public Safety Act. So three-time Chief Minister Farooq Abdullah was charged under the Public Safety Act. He was also released a few months ago. But when he was charged under the Public Safety Act, there was much amusement in Kashmir because mainstream politicians are quite despised over there. And people commented how his father brought this legislation into effect, and his son has now been charged with the same legislation. But apart from the amusement of that from Kashmiris, the interesting thing to note over here was that Farooq Abdullah was charged under the Public Safety Act only after DMK President MK Stalin filed a habeas corpus petition in court. And that time the court said, before he had been charged under the PSA, the court said the court was informed that he is not in detention. In fact, the Times of India came out with a report, a story saying that Farooq Abdullah is throwing a tantrum and he has locked himself in his own home. So it is also one of the reasons that Shah Faisal withdrew his habeas corpus petition, because as an ex-IAS officer, he knows that if you express resistance against the center will come down harder on you. Now, in practice, even minors had been arrested under the Public Safety Act using generic orders which have no application of mind. After August 5, the Supreme Court's own committee identified that at least 144 minors had been detained. But soon after this report came out, the Jammu and Kashmir High Court submitted its own report saying that no minors are in detention. And after August 5, not just children, but political dissidents in Kashmir, political leaders in Kashmir, from all shades of political opinion, they had been detained. And in order to suppress the expected flurry of litigation against the decision to amend Article 370, as well as against the detention of people, hundreds of Kashmiris, including lawyers, have been arrested by the Indian government in contravention of United Nations basic principles of role of lawyers. So from the UK, the chair of the Bar Council, Richard Atkins, as well as the chair of the Bar Human Rights Committee of England and Wales, they both wrote to Narendra Modi expressing serious concern over the effective suspension of habeas corpus and the arrest of Kashmiri lawyers. Now, even right now, there are nearly 200 habeas corpus petitions that are still pending of the original 400, which had been filed since August 5. And it's now been 9 months that these petitions are pending. In addition to the people who have been detained under the Public Safety Act, there are many who have just been detained without invocation of any law. Many people have been detained without even being informed what law or what charges are against them. And it must be underscored over here that an impact on democratic freedom could normally be remedied by a functional legal system. But a dysfunctional legal system has rendered all rights meaningless. It's interesting to note over here that the Public Safety Act's own procedure, if I speak about how the court proceedings go, the Public Safety Act's own procedure is rarely followed. You see, the Public Safety Act is already a very draconian law, but statistically, it has been seen that nearly 80% of the cases under the Public Safety Act are dismissed on procedural grounds, which means that even the procedure which is established under an already draconian law is not followed. So, and it's ironical that even for an order in which due process and procedure was not followed, to get that order vacated, it still takes 2 to 3 months under normal circumstances, let alone in a time when COVID, because of the COVID virus, the court's also not functioning normally, and all the proceedings are happening through video conferencing. Now, in addition to all of this, the Indian government now exercises direct control over Kashmir. They can arrest any Kashmiri, send them to any jail in India, thousands of kilometers away, as they have done right now. Many Kashmiris are in jails in Uttar Pradesh, in Rajasthan, many kilometers away from home, making it difficult for their lawyers and their families to visit them. Apart from the Public Safety Act, Kashmir also has the Armed Forces Special Powers Act, under which armed forces get legal immunity for actions that they undertake in Kashmir. There is no trial in any civilian court for actions that they engage in, and the extent of force that they can utilize under the Armed Forces Special Powers Act, it extends to causing of death. There is no trial in a civilian court for this. And despite all the egregious violence that has taken place in Kashmir, all the human rights violations that have taken place over the last 30 years alone, there is hardly any Indian soldier who is serving a jail sentence for crimes committed in Kashmir. And now, of late, the recent innovation has been using the NIA to harass Kashmiri leaders. So Yasin Malik, Asya Andarabi, Engineer Rashid, they've all been, they're all are under the NIA investigations now. and they have attached properties of most of these leaders to harass them further. They are opening up 30-year-old cases against them, whereas the same thing is not done in other situations. So there are differential parameters being used in a dispensation of justice. For example, Pandit groups had approached the Supreme Court a few years ago asking for investigation into the killings of Pandits in Kashmir. But the Supreme Court said that it's been too long, all the evidence is gone. It's been less than 30 years. But in the same instance, a 30-year-old case has been opened up against Yasin Malik. So it finally, this point brings me to an area that I want to discuss specifically with what has happened today. You see, today in the morning, the Supreme Court passed its verdict refusing a plea for restoration of 4G internet in Kashmir. I want to discuss the role of the judiciary in legalizing or allowing the government to violate fundamental rights of Kashmiris. The Supreme Court has held that there needs to be a balance between national security and human rights. And while the court is saying that there needs to be a balance, the judgment itself has clearly prioritized one over the other. And the court set up a special committee headed by the Secretary of India's Ministry of Home Affairs to decide if the orders passed by the same ministry are appropriate or not. It's an ironic reminder that by the Supreme Court that in India, the doctrine of separation of powers is not codified in the constitution. These are just directive principles which are not justiciable, they're not enforceable anyway. And this committee is now going to examine the requirement of internet in Kashmir and other concerns of the petitioners. So it's relevant to mention here that the petitioners had argued that 4G speed was essential for healthcare, for education, for trade and business in Kashmir. And they even highlighted how today in Kashmir, there are nearly over 700 cases of COVID. When this petition had been filed, there were just 33 cases. And doctors need 4G internet speed for online consultation with their patients. But even they argue that even the Arogya Sethi app, which is mandated by the Modi government, cannot be downloaded in 2G speed, which has just been activated in Kashmir last month. And in response to all of this, the Solicitor General of India, Tushar Mehta, blithely commented that there is no information of anyone, there is no data available of anyone dying of COVID due to lack of internet access. Now, these restrictions in Kashmir, these restrictions on communication, on free expression, they are inconsistent with fundamental norms of necessity and proportionality. This judgment which came out today, it implies that the Supreme Court has abdicated its responsibility to adjudicate and decide if the orders of the MHA are excessive, arbitrary, or unconstitutional. But earlier also in January, it took the court 5 months to decide on the lockdown in Kashmir. And yet after 5 months also, there was no decision on the validity of the restrictions. There was just a deferral of the court's responsibility. So in conclusion, I would just like to remind the Supreme Court of India that the structure of the internet is too vast to be defined merely as a tool for communication, because it affects every possible activity, many of which are not even communicative in the human sense of communication. So in the light of this understanding, the ban, these indefinite restrictions on communication in Kashmir, they must be viewed as arbitrary, they must be viewed as sweeping and unconstitutional violation of the fundamental rights of Kashmiris who are affected. Now, the Supreme Court of India is the final arbiter on all issues, but the court must be reminded that national interest as defined by a government in power is not a ground for justification for restriction, and it's not a reasonable restriction on fundamental rights and basic human rights. But the consistent inability of the court to do its only job is an abdication of the responsibility of the court. And all it establishes from a Kashmiri perspective is that Kashmir lies outside the moral and legal compass of India. I'm happy to take any questions that you may have towards the end. There are just some drawings that I'd shared with Mansi, which I'll request if she can share on the screen right now, because these just cover recent events that are taking place in Kashmir, and they may be better for an audience to connect. These drawings have been made by members of the Kashmir Reading Room. You can check out their page and Instagram link, which will be shared with you later. So this is the first drawing, which was Jammu and Kashmir needs internet to fight COVID-19. This is based on a real occurrence where the doctors in Kashmir were trying to download a 24 MB file, which the NHS in the UK, NHS doctors in the UK had uploaded, giving their learnings of how to fight the COVID crisis, the COVID emergency measures that doctors needed to adopt. It took doctors in Kashmir 8 hours to download this 24 MB file. So this is just a representation of how the government of India doesn't really care about what happens in Kashmir. And if I could request you to move to the next image. So this is just a picture of which captures what Sabka Saath, Sabka Vikas really means in Kashmir. The first image on the left is of the internet being cut down. The second one on top of that is the change of names in Kashmir. So many of our departments in the government, their names are being changed to more Hindi-sounding names. And there's talk that maybe the state language will also be changed to Hindi. In Kashmir, there are not many people who can read and write Hindi. It sounds very similar to Urdu in most of the words, but reading and writing in Urdu, there are not many people who know that. So this is a move which is being effected to engage employment from Indians and not from Kashmiris. The other images over there are about the Public Safety Act and the environmental deforestation that is taking place, because the Modi government, while Kashmir has no elected government in place, has passed over 125 projects covering hundreds of hectares. In fact, 270 hectares of our forest land is being deforested to make way for developmental projects, which we have never asked for. This is going to cause irreversible damage to our ecology, and there's no way we can raise our voices against it, because anyone who speaks against what the government is doing is being detained and charged with an anti-terror legislation. Could you please move to the next one? So this is just one point I had to make, because in last month, while Kashmir had an internet shutdown, while the internet was restricted in Kashmir, all tenders for mining in Kashmir were done through an online process for the first time. This is the first time the tenders were done online. So there was no way for Kashmiri businessmen to engage to bid for these tenders, but some of them went outside Kashmir to circumvent the internet ban and bid for the tenders. But they were just unable to compete against the bids that were being made by Indian businessmen. And the reason I'm making a distinction over here is because until August 5, Indian citizens were not allowed to engage in mining activities in Kashmir, because Kashmir had a state subject rule, under which only people who are subjects of the state of Jammu and Kashmir, they get employment rights in Kashmir, only they get the right to buy land in Kashmir, as well as mining operations in Kashmir. So this is the first time it happened, and because of the way the government of India effected it, 100% of all tenders went to Indian businessmen. None of the tenders were able to be taken up by Kashmiri businessmen. If you could move to the next slide, I think that's the last one. So finally, this is one something that had to be brought home, which is that in Kashmir, it's while the world is trying to fight this corona epidemic, the pandemic, it's interesting to note that in Kashmir we have one ventilator for 71,000 patients. We have one doctor for 3,900 patients. But to add over here, there are nearly for every 10 Kashmiris there is one armed gunman. So while the Indian government has, and even the Pakistani government does not really have funds to provide for PPE or provide for tests for its citizens, both these nations are exchanging in heavy heavy artillery fire against each other, even while we speak right now. Every single day there is across the LOC, there's shelling taking place right now, and over the last month, nearly 20 people have been killed in this cross LOC shelling. So I think that's the last one. Manisha, if you can tell me, Mansi, sorry. Yeah, that's the last one. So I'm happy to take any questions that you have on developments in Kashmir that are taking place, or any legal issues that come to mind. Thank you.
Thank you, Mirza Saaib, for your presentation. Now we will open for the audience questions. We have received several questions from our audience. It is good to see that still there are 74 people with us attending this. I could see there were around 87, 86 people in the beginning. It's really heartening that so many people are with us. So one question, this is a broad question. and it concerns all the laws, draconian laws we have discussed. It concerns to that. Is uh, what should be done? What is the way forward? I mean, is there any, say, check and balances? The question is to counter these check and balances that can be put in place to counter these draconian laws. Manisha, Mirza Saaib, Bela, briefly, because we are running out of time.
Okay, unmuted. See, firstly, I think it's also important to put out a counter narrative. I think that's also part of what one needs to do, because we are so overwhelmed by this whole, jingoism and this toxic sort of, jingoism that we are surrounded by, where from the courts up to, everybody else is, buying into this argument that, somehow this idea of national security, which is constructed by the state, it trumps fundamental rights, or our citizen rights as citizens. So I think that for us, for many of us, who are not lawyers or not engaged in direct legal work, part of the job is to create that counter narrative, to question and critique the dominant, the story that comes out. So I think from where I come from, one can only do that, to ask questions, to raise questions.
Okay. मिर्जा साहब, आप कुछ ऐड करना चाहेंगे?
Yeah, I completely agree with Manisha. I think I'll just add this much, that from a Kashmiri perspective, see, it's very difficult for Kashmir to vocalize. In fact, most of the things I've said today, it's often difficult to talk openly about these things, because there are different levels of violence that get legitimized against Kashmiris the moment they assert an opposition to the government of India. So because of that, I feel that as Kashmiris, what we require is, we need safe spaces. We need Indians to stand with us, to allow us to freely dissent politically, to express ourselves. And that, I feel, is the only way India also can democratize itself. I feel one of the big challenges in India is that it's not really a democratized nation, because there is every kind of colonial law, and the people also accept what the government is telling them, especially on Kashmir. If you talk to Indians anywhere, they will tell you that their politicians are liars, and everyone's a thief, and the media is misleading them. But when you talk to them about Kashmir, they always believe whatever the politicians tell them, and they believe what the media is giving them. So what we require is a real democratization of India, where there should be free political dissent. And for that, as Kashmiris, we need Indians to keep providing us safe spaces. We need Indians to stand with us, stand by us, because Indians have certain privileges in India which Kashmiris do not have.
बेला, आप कुछ ऐड करना चाहेंगे?
Well, I agree with both our friends. I just feel that we need a concerted campaign against these special laws, a campaign, which extends itself in the public as well as, जो लोग कानून बनाते हैं. तो सबके बीच में हमें ये पूरी बात ले जानी है, क्योंकि कई बार, मतलब हम जानते हैं कि जिन पर इस तरह के आरोप लगते हैं, वो पूरे लंबे प्रोसेस के बाद में छूटते भी हैं. They do get acquitted because there's nothing against them. So, to bring out these cases about how it is just, terrorizing people, and that we don't need special laws, that IPC is enough.
बेला, एक सवाल आपके लिए है, स्पेसिफिकली वो ये कि हाल के दिनों में जो माइनिंग एक्टिविटीज को लेकर के प्रोटेस्ट हुआ है और रिसेंट चेंजेस है, उस पर अगर आप कुछ कहना चाहती हैं, जैसे बेला डीला का माइनिंग है, या फिर आप ये देखिए कि अभी मार्च में एनजीटी पास्ड अ वेरी गुड ऑर्डर asking Jindal and SECL to pay, making them polluter and pay the मतलब उसको रायगढ़ में जो कुछ हुआ, तो do you see any change on the ground? Because ये भी कहा जाता है और देखने को मिला है बहुत सारे स्टडी से कि ये जो मिलिटराइजेशन हुआ बस्तर का, साउथ छत्तीसगढ़ का तो हुआ ही, लेकिन नॉर्थ छत्तीसगढ़ में भी हम देखेंगे कोरबा और रायगढ़, ये सब जो इलाके हैं उसमें पॉल्यूशन और ये सब चीजें हुए। उसकी मिलिटराइजेशन की एक वजह ये थी कि जो नेचुरल रिसोर्सेज है उस पर कहीं ना कहीं कब्जा करने का असल मकसद ये था। तो इस पर आप अगर कुछ कहना चाहें।
मुझे लगता है कि ये दोनों जगह में ये रायगढ़ एरिया में भी और किरंदुल साइड में, दोनों जगह में ये जो पॉजिटिव एक हम लोग को दिखा है वो लोगों के आंदोलन का नतीजा है। दोनों साइड में लोगों का आंदोलन बहुत स्ट्रांग था और इस बार ये हुआ है कि गवर्नमेंट ने ये कहा था कि मतलब पहले जो भी कानूनों का उल्लंघन हुआ, जैसे कि इन किरंदुल साइड the Gram Sabha, there was a farji Gram Sabha, the PESA Act had not been respected. So the government had given this kind of an आश्वासन कि हम पालन करेंगे और उन्होंने एटलीस्ट मतलब वहाँ पे हम लोग को देखने को मिला कि उन्होंने किया। So I mean there's not that much to say, I mean because the question remains that the military is still on the ground. I mean there are troops, more than 60,000 to 70,000 troops still on the ground. बात तो तब बनेगी जब डीमिलिटराइजेशन होगा। हमें इतने ट्रूप्स की क्या जरूरत है बस्तर में? तो जो कुछ भी बात है वो बिना ट्रूप्स के सामने टेबल पर और लोगों के हक अधिकारों की बात है ये पूरी। इसमें हमें इतना ये हथियार क्यों चाहिए? तो बात तो तब बनेगी अगर ये पूरे हथियार वापस ले लिए जाएं और माओइस्ट से कोई शर्त नहीं रखें कि आप अपना हथियार पहले नीचे रखें फिर बात करेंगे। ये गलत बात है। वो एक पॉलिटिकल मूवमेंट है, इसलिए उससे ये शर्त करना गलत बात है। उनसे बातचीत की जाए, वो हमारे ही देश के नागरिक हैं और as I said before, I would really like to call for demilitarization. Bastar has been under the shadow of the gun for too long, and there are too many tears and too much blood that has flowed यहाँ पर, and all in vain. कोई फायदा नहीं हुआ है, किसी की जीत नहीं हुई है, सबकी हार हुई है।
थैंक यू बेला। एक सवाल ये है कि आई थिंक द क्वेश्चन इज कि ये जो इश्यूज हैं, व्हाट इज हैपनिंग in India, in Kashmir, in Delhi, in Chhattisgarh, is there any possibility to take it to the international forum, and whether it will be useful or not? That is a question being asked, and so maybe Mirza, Saaib, you can say, you can start, and then Manisha and Bela can add from their experience.
Yes. Well, specifically, there has been some international attention, especially on Kashmir in the last 9 months since August 5. There's been a lot of international attention. It doesn't seem to have a lot of effect because it depends on how sensitive the government in power is to international criticism. But if I were to highlight this, see, there's been a hearing in the United States Senate on Kashmir. There have been resolutions passed by various governments on Kashmir. There have been various statements made. In fact, the United Nations representatives, they made statements saying that India's actions in Kashmir, especially on the internet ban, they are violative of Article 19 of the Universal Declaration of Human Rights. Also, what India is now trying to engage in by changing the domicile law of Kashmir, after which Indian citizens will now be allowed to buy land and get employment in Kashmir. By that, they are trying to engage in a demographic change. This may be in violation of the Geneva Convention also. Now, this is the laws that are being violated. Now, can it be taken before an international forum or not? Should it be taken before an international forum or not? That's the second part. As Kashmiris, it's not possible to take it before the international forum because we are not a state. ICJ will it will only entertain this a complaint by a state. But there are other forums where it can be advocated, it can be vocalized, but they're not binding on India. And India has been very meticulous in ensuring that it does not allow any third-party jurisdiction over its disputes. So international forums don't really cannot issue a binding judgment on these issues over India. So even if they were to issue judgments, they do have persuasive value, and they have a value in PR, but not something which has an effect on ground. And like I said, it really depends on how sensitive the government in power is to these things. But of late, if you notice, there has been a lot of noise even from Middle East countries against Islamophobia in India. And there was a slight change. In fact, even Sudhir Chaudhary was preaching about Islam the other day, which was quite interesting to watch, where Sudhir Chaudhary was talking about what jihad means, what jihad does not mean. But it's interesting. Of course, international pressure does make a difference, but only when it has economic consequences. Because there seem to be economic consequences coming from the criticism of Middle East, where even some of the royal family has criticized what is happening in India, the rise of Islamophobia, the rise of this virulent anger against Muslims and also against Kashmiris. So that if that criticism, that international criticism, is accompanied by economic consequences, then it may have some results on ground.
Okay, Manisha.
Yeah, well, I agree. There've been a range of agencies who have spoken out. You had the U.S. Council on Freedom of Religion, which recently, in a statement, pointed out to India as a country of concern. Prior to that, we've had various UN agencies calling out, the discriminatory nature of the the CA, the Citizenship Amendment Act, and the way in which the government was, coming down on dissent and so on. So there has been, and then of course what's been happening in the Middle East, the calling out of Islamophobia in India. So I think it does have some impact. Whether or not one actually goes to a particular forum or not is for for legal minds to decide. But I think this international sort of, and I think never in the last 20-30 years one has seen the kind of this image of India as a democracy, as so on and so forth, which was predominant image in the minds internationally, is now taken a beating, that's for sure. And there is a general, I think, understanding outside that there is something terrible which is going on here. And yeah, of course, it doesn't, it seems that the government seems to be impervious to what, and we know that political leaders are able to capitalize on it by turning it around in their favor. That happens all the time. But I think they're also sensitive to that, because otherwise they wouldn't have gone after many journalists who wrote, cover stories for Times and so on. So there is a pressure that works, and I think it is, if there are campaigns which take up these issues, then certainly, these things will come out more and more.
Bela?
Well, internationally, I think if people and organizations work together, that is, of course, always welcome, because we need to, gain strength at that level. The United Nations has disappointed us too many times. We have outstanding wounds, which are not healing. It is shocking to us to continue to see what's happening in Palestine, what is happening in Kashmir, Tibet, Afghanistan. I mean, I think, there are so many, examples of this kind. So there's no doubt about it that at the international level, just as we say here, we the people of India, I mean, we the people of the world, I mean, there's no doubt about it that we have to, build our connections, and, we have to together, join and gain strength and fight the Goliath or Goliaths.
So we are running out of time, I'm told, and we have to finish it by say 9:15. We are already, say it's already 9:10. So I have last question which I'm allowed to ask, and I'm sorry. There were several questions, but due to time constraint, we won't be able to take further questions. So I'm sorry on behalf of the organizers, and maybe it was my inability also to moderate it more properly. So my question is कि एक आम शहरी, एक आम सिटीजन होने के तौर पर, as an ordinary citizen, not being an activist, not being a political actor, what we can do, an ordinary person can do. We know the situation. What should be our role given the situation, what we are witnessing across the country, and especially in certain areas of the country. Bela.
I think first and foremost, I think we should be better. It's our responsibility to be better informed, because I'm really shocked at how sometimes in our own circles, people are just swallowing propaganda. And in recent times we have seen a lot of that, and that's very, very shocking and heartrending if you're related to some of these persons. So therefore, I think first and foremost, as educated persons, it is our own responsibility to watch very many different types of channels, read very many different types of newspapers, and be better informed, be critical. So that is one. And secondly, that don't forget that the question mark is the most um, um, uh, democratic of all the punctuation marks. Keep asking questions.
Mirza Saaib?
Well, in one word, if I were to say what a common person should be doing or can do, at the very least, the one word I would say is empathize. I feel that one thing that is completely lost in India right now is empathy. When you see children being tortured and brutalized in Kashmir, you accept the argument that maybe they deserved it, maybe they did something anti-India, maybe this child, 11-year-old, 10-year-old, 9-year-old child is a threat to the integrity of India. When you see a woman who's saying that she has been sexually violated, you're saying that no, this woman is probably trying to defame the Indian army. So the least I would say for any common person in India is learn to empathize, and then beyond that, learn to educate yourself, learn to organize, and then you agitate. So if these things can be done, I'm sure we will have some progress on all our struggles. But just to add one thing, I do feel that the people leading different struggles in India, we need to learn more from each other and connect, because I do feel that all these struggles exist in their own silos. Our struggles in Kashmir are existing in their own plane. Struggles in India exist in their own plane. And I do understand the difference between the political objectives of these struggles, but we have to learn more from struggles and connect with each other, because essentially we are fighting similar forms of oppression.
Manisha?
I have nothing more to add. I mean, they've said it all. I mean, to act humanely, to think like a human being, and to question all the time, not to be gullible, and perhaps not to believe the WhatsApp so much. I think these are the things that one should start with, and then, because I think one of the things is because on a lot of these, speaking of WhatsApp, we see a lot of times people on various WhatsApp groups pouring forth absolute bile, right? And I think as just ordinary people, it is important for us to question that each time, not to allow that to become the dominant narrative. In wherever little places, whether it's our little school or school WhatsApp groups, or our RWAs, or wherever we are in our professional capacities and our personal places, we ought to question and not allow hate to become the dominant narrative. I think perhaps we could start with just that.
Thank you everyone. Thank you Bela, thank you Manisha, thank you Mirza Saaib, and thank you our audience. I can see 60 people right now, so it was great having all of you, and I'm sure this was just the beginning. You will read more about these laws and these issues, and we will, again, we'll keep discussing these things, and not just discuss, but also try to act in whatever small or big manner we can. Thank you. And thank you to the organizers, Shamil Ahmedabad, especially Manisha and Iravati, for having us and asking me to moderate this.
Thank you.
Thank you all.
Thank you.
Thank you.
Thank you for having us. Are we offline?